As we enter into a new year, experts say that wills and estate planning are not just for the wealthy, it's for us too. Local attorney Yetunde Aird is joining us this morning to offer these estate planning tips, essential estate planning tips. Okay, so when you say hi first.
Good morning, Kanji.
Yeah, so when you say the word estate, it just feels intimidating. Can you just explain what is estate planning and why it's important?
Absolutely. Well, thank you so much for having me. And as a disclaimer, this is not legal advice. It's for informational purposes only. But as we are starting the new year, estate planning is very important. What is estate planning? Estate planning is an umbrella of legal documents that someone can use to make sure that who they designate takes care of affairs for them when they are unable to do so, whether here on earth or after they have transitioned.
That's right, because people can, things can happen and you might need someone to make medical decisions and all that kind of stuff. So what are some misconceptions about estate planning?
Absolutely. Some misconceptions about estate planning is that you have to be an elder person. Some younger adults say, hey, I'm only this age, I don't need an estate plan. I truly believe that every adult should have an estate plan, whether it is a power of attorney for health care or a power of attorney for finances, or even a living will if someone is ever incapacitated and in a terminal illness stage. But again, that can happen at any age of life. Also, some people think, oh, if I'm not married or I don't have any children, I may not need an estate plan, but you actually do.
Because it goes to the state, right? If you don't, if you have money.
There are some default laws, right, that go into effect if someone does not have a will or a trust or whatever estate plan matches what their needs are.
Right, okay. I mean, I know I have a living will and I'm like, if I'm in a coma for so much time, then, take me out or, just write too much information. But, can you explain what an advanced directive and a living will are?
Absolutely. So an advanced directive is, again, a legal document where it can compose of a power of attorney for health care as well as a living will. Think of designating someone who you trust to handle those affairs for you. You can designate a primary agent as well as a secondary agent to, again, make those decisions on your behalf for a certain season or if you are unable to, whereas a living will is, in a nutshell, you're still living, but if you are in that terminal illness stage, you already have those wishes spelled out so that the person who is assisting you, again, as your agent, knows what your wishes are. There is no confusion. So in essence, it is a love letter because you are telling your loved ones what you would like to happen if that scenario ever arises.
Wow. And okay, explain a power of attorney because, and I know that when you pass away, that doesn't last anymore, right? So you have a power of attorney for when you're alive, and what is a power of attorney?
Absolutely, that is a very great question. So a lot of times you'll hear POA, which stands for power of attorney. The two main documents are power of attorney for health care or durable power of attorney for health care. In case you are ever incapacitated, it still goes on. But if someone transitions from this earth, the power of attorney is no longer valid. And that is when, if you do have a will, the will kicks in, that final will. Now, in a final will, you can designate an executor, right, to handle those affairs for you, to make sure that your assets are divvied out between your heirs and your beneficiaries. You can designate any possible funeral arrangements. And also, if you have minor children, unfortunately, there are some times when an adult or a parent may pass before their children are adults. You can designate legal guardians in your will. And so you can be very creative in a final will. And again, that is a love letter because you're not leaving back that confusion once there is that transition.
Okay, and you say that you shouldn't necessarily wait until your retirement age. Can you just speak to that and talk about just kind of the list of things you need to go down?
Absolutely. I believe as soon as someone is emancipated, right, typically it's 18,
means your parents don't be watching you. No,
Exactly.
I'm sorry,
Well-
you're just so smart. And you have like, yes, you just have like a whole glossary and you're so, okay, sorry, go ahead.
No, thank you, Kanji. You as well. And, you know, college students, they're so used to their parents making
Right.
those decisions for them. But think about it, when you go off to college, if something does happen in regards to your health care finances, your parents as a minor are no longer your default. And so you, even as an 18-year-old or a young adult, still need to have, for example, a power of attorney, and you don't have to designate your parents. It just
Yes.
needs to be someone that you trust.
All right, because it's not always family,
It's
right?
not always family. It can
Sadly.
be, yeah, it can be a best friend, it can be a colleague, and that is one of the misconceptions as well, is that you can only designate family members, and that is not true.
Wow. Okay. So I do have to ask, when someone comes to you in this situation, because I know this is what you manage, do they come with like a stack of papers, or what do they bring?
Absolutely. And so if you go to our website, which is www.yourboutiquefirm.com, you can select a consultation, specifically for this, an estate planning consultation. And before we meet, you will fill out a questionnaire, and I will go through all of those questions with you, make sure you understand what all of these terms mean, because there are a lot of legal jargon that, if you're a layperson, you may not understand, and it is okay. That's why I always advise, please hire an attorney for something as important as this. Don't just go online and download a random template or document, because you may not understand what it means, but more importantly, it may not be valid. For example, for a final will, there is a way to make it valid with witnesses, with a notary, and it has to have specific language in that legal document.
All right, Attorney Yatende Aird, thank you so much for your time
Thank you
and
so
this
much.
information. The love letter to your family.